We see you, Mr. Goldman. We're just waiting for Mr. Cortinas.
Yes, sir.
And there's Mr. Cortinas. So thank you both. This is Bickett versus Bickett. Mr. Cortinas, you're up.
Thank you. Good morning, Your Honors. May it please the court. Angel Cortinas and Bill Schifino from Gunster on behalf of the appellants, Patricia Bickett, James Bickett Jr., Paul Bickett, and David Bickett. I'd like to reserve 5 minutes for rebuttal, Your Honor.
Very good.
Thank you. Judge, the trial court granted the appellee's Rule 1.540 motion to set aside the order appointing the appellants as personal representatives of their late father, James Bickett's estate. As a result of that order, removing the appellants as personal representatives, the trial court also set aside court-approved property transfers that appellants made as personal representatives. The trial court reversibly erred, Your Honors, on three primary grounds. First, the trial court erred as a matter of law in concluding that the appellees were entitled to notice of the appellant's appointments as personal representative of James Bickett's estate. Under well-settled law, the appellees had no legal interest whatsoever in Mr. Bickett's estate and therefore were not entitled to notice of appellant's appointment as personal representatives. And that is reviewed de novo by this court since it was a conclusion of law by the trial court. Secondly, Your Honors, the appellee's Rule 1.540 motion was an impermissible way to attempt to remove a personal representative under clear Florida law. And one of the cases we cited for Your Honors is a case called Bleckman v. Dely, D-E-L-Y, from the 4th District. And the 4th District says, correctly so, that the removal of a personal representative chosen by the deceased is a drastic remedy and should only be resorted to when the administration of the estate is in danger. They go on to point out, which is what we're saying in this case, that the Florida probate rules set forth the procedures that must be followed for removal of a personal representative. And then it provides in pertinent part what the procedures are, which are the ones that we're arguing in this case. And in that case, they did not file a petition for removal. And accordingly, what the 4th District did is that they reversed and remanded with instructions to reappoint the personal representatives. Here we have Florida Probate Rule 5.025 that requires formal adversary proceedings to remove a personal representative and requires that those proceedings be conducted like a civil case, which includes an answer, affirmative defenses, discovery, and a trial. Section 733.301 of the Florida statute expressly covers removal of PRs based on lack of notice, as they say in this case, and requiring formal notice and a hearing. Here, those sections and probate rules are what they should have done. As the court well knows from the record, the appellees had already had a current petition pending a petition that they had amended at the time they filed their Rule 1.540 motion. To the extent they wish to proceed to remove the appellants as personal representatives, the proper way is to have done it through a petition and not through their end run around, which they did through their Rule 1.540 motion. In any event, Rule 1.540 was entirely inapplicable to these particular orders appointing a personal representative because, as the court knows, these are not final orders. The orders appointing personal representatives are not final orders that would come under the purview of 1.540. And finally, the third reason for reversal, Your Honors, is even assuming for argument's sake that the Rule 1.540 motion was proper, and it was not, here it would have to be reversed because the court granted the Rule 1.540 motion without an evidentiary hearing and without allowing the appellants to complete discovery. I'll address the first issue, Your Honor, which is as a matter of law that the appellees had no legal interest in the estate of their late father, James Bickett. The appellants and the appellees are the only children of Mr. and Mrs. Bickett. Mrs. Bickett was Mr. Bickett's sole heir, sole beneficiary, and the only person named as personal representative in Mr. Bickett's will. None of Mr. Bickett's children had any legal interest in Mr. Bickett's estate at the time of his death. Only their mother, Mrs. Bickett, did. Mrs. Bickett was already in her 80s when Mr. Bickett passed away on November 29th, 2016.
Cortinas, were the children contingent beneficiaries under the will?
They weren't under, they were not contingent beneficiaries under Mr. Bickett's will. The only beneficiary under Mr. Bickett's will was Mrs. Bickett. The children were contingent beneficiaries under the will and trust, a revocable trust of Mrs. Bickett. But that didn't come into play.
There was no mention of the children in the father's will?
The only heir and the sole beneficiary in the father's will was Mrs. Bickett.
And what did the will provide if she predeceased her husband?
I don't know that that's in the record if she predeceased the husband. In fact, Your Honor, as the court knows, when Mr. Bickett died, the parties didn't even believe that Mr. and Mrs. Bickett didn't know that he had a will. And it was only later that we know from the probate attorney that it was discovered that Mr. Bickett had left a will.
If there was no will, would the children have had any interest as intestate beneficiaries?
I'm not sure, Your Honor.
The record does not address any of that, does it?
It does not. And what we have here is that after Mr. Bickett passed away, the only beneficiary, Mrs. Bickett, chose the appellants, the 4 children who worked on the family farm for many years, as the personal representatives of Mr. Bickett's estate. In December of 2016, the trial court appointed the appellants as personal representatives of Mr. Bickett's estate. After the appellants had been appointed as personal representatives, the trial court granted their request to transfer certain properties to a company owned by Mrs. Bickett through a revocable trust. All that did is transfer the properties, but the ultimate ownership remained at all times with Mrs. Bickett. At the time the appellants were appointed as personal representatives and the properties were transferred, Mrs. Bickett had a will and a revocable trust. The will and the revocable trust of Mrs. Bickett named all of the Bickett children as beneficiaries. Thus,
Mr. Cortinas, so in essence, you're asking us to follow the more specific statute, correct? Which applies here, which is what they should have done as far as the removal of the personal representative, because we are in probate. And has 1.540 ever been used to remove a personal representative or vacate an order?
You know, Your Honor, that's a very good question. I'm not aware of any case where they tried to use 1.540 to remove a personal representative. The best case that I found on that was the Bleckman case, which I addressed to the court, where they tried to remove them through an order, a motion for removal. But you know, clearly, Your Honor is correct. The proper procedure was to do the specific way that the probate code and rules and statutes provide for removal of the personal representative.
And that would have instituted an adversary proceeding, is that right?
Yeah, and there was one already going on. There was already a petition going on because after Mrs. Bickett passed away, and this was about many months after Mrs. Bickett passed away, the appellees filed a petition to void the 2 orders transferring the properties.
Okay, but so let me clarify then. The 1.540 motion was not filed in that adversary proceeding, correct? It was just filed in the general probate case.
Correct, Your Honor.
Okay.
Correct. That's exactly what happened. The In October of 2017, Mrs. Bickett passed away, and 6 months after she passed away, the appellees filed a petition in the probate case. And then over a year later, while those adversary proceedings were pending, in this particular case, they filed a 1.540 motion seeking to vacate the orders appointing appellants as PRs and the orders allowing the transfer of property. They argued in their 1.540 motion that they were entitled to notice of the appellant's appointment as personal representative of Mr. Bickett's estate at the time of his death, which, as we have pointed out in our briefs and in argument, they were not as a matter of clear Florida law. And the cases that talk about them having no interest whatsoever, and they're in our brief, is Genova, Darien, Bundage, and Ullman, and they all stand for the proposition that a revocable trust, which is what Mrs. Bickett had, that it has no legal significance until the settler's death. So until that moment happens, they are not interested persons in Mr. Bickett's estate. And their argument is basically defeated by those unbroken string of cases that say that unvested beneficiaries have no legal interest in a will or revocable trust. Now, there's no question, of course, that today the appellees have a legal interest in Mrs. Bickett's estate and trust, but that interest, as we pointed out, only arose upon Mrs. Bickett's death and does not retroactively confer upon them the right to notice during her lifetime. That issue alone is fatal to the order on appeal, since it was the sole basis for the trial court's decision. Your Honors, Rule 1.540 does not apply to motions to remove personal representatives. We pointed out that the proper procedure is the adversary procedures and the specific rules in the probate code.
Mr. Carthusis, one question I have relates to the sequence of events. After Mr. Bickett died, the co-personal representatives were appointed, and then sometime later, the co-personal representatives filed their motion to allow certain properties to be conveyed in a manner that was not contemplated under Mr. Bickett's will. Is that correct?
I don't believe so, Your Honor. They were conveyed. Those properties that were later conveyed, they were still under the control of Mrs. Bickett. So those properties that were conveyed, and those are the ones that the court has stayed right now. Those particular properties were done in their capacity as personal representatives, and Mrs. Bickett remained in control of those properties.
So she remained in control how?
There were
assets that were being devised under Mr. Bickett's will to her trust, if I remember correctly. Everything that's what I think ended up happening to a trust that she controlled. But remember, when Mr. Bickett passes away, everything from Mr. Bickett, none of it goes to any of the children, whether they be the appellants or the appellees. But the point that I'm trying to get to in terms of this sequence is the 4 children filed a motion to allow this conveyance instead of to the trust, to the LLC. Do we agree on that point?
Yes.
Okay, so now I want to sort of backpedal a little bit. The court seemed to have been persuaded that the reason for notice was perhaps not because of any interest in Mr. Bickett's estate, but because of this effort to change the manner in which property was being devised, instead of to Mrs. Bickett's trust, to the LLC. And the court seemed to have determined that the children were entitled to notice because they were contingent beneficiaries of something that was taking place relating to her estate. It's a sort of roundabout way to get there, but am I reading that's what the court seemed to be concluding?
You know, I'm not so sure, because they talk about them being interested. The court says in their order under Rule 1.540, and incorrectly so, the court says that the movements, being the appellees, were interested persons in the proceeding resulting in those orders. And yes, Your Honor, he's referring to the orders appointing the personal representative and the orders transferring property, and were not afforded notice and opportunity to be heard in those proceedings. And our response to that, Your Honor, is as a matter of clear Florida law, the appellees were not interested persons, because while Mrs. Bickett was alive, all that was done pertaining to Mr. Bickett's estate, including the transfers of property by the appellants, and it going to still being in control of Mrs. Bickett, they were not interested persons. They only became interested persons under Florida law when Mrs. Bickett passed away, and not before.
Mr. Cortinas, you're at your 5-minute time. This is a complicated case, so unless the panel has other questions right now, then you can go ahead and reserve. So
Thank
I
you,
don't
Judge.
hear any more questions right now, but we'll reserve the 5 minutes. And Mr. Goldman, we're ready for you.
Thank you, Judge. May it please the court, I want to answer Judge Smith's question regarding the civil rules quickly, and then I have 3 areas I thought I would spend my time on, subject, of course, to answering any of your questions, but to use my time and in part address some of the reply brief, which is my only opportunity to do that. So Judge Smith, there was never, ever an argument below in these proceedings that the civil rules did not apply to this 1.540 motion. Never made. It's new to Mr. Cortinas. In fact, the rules were followed. The entire proceeding was declared adversary, and so Rule 1.540 applies. There was
okay. How declared adversary? Because my understanding of adversary proceedings, well, to remove a PR would have been under the statute, a petition, a summons, a response. So what do you mean that they were declared? I mean, obviously they were adversarial, right? I would agree with that. But what do you mean they were declared an adversary proceeding? The judge converted your motion to an adversary proceeding?
There were 3 generations of that motion. The first one of which was declared adversary, along with, remember, in this case, there's a will contest and a trust contest. Well,
right.
There's also petitions to set aside other deeds, all declared adversary. But I want to separate that from removal, because Mr. Cortinas, and I understand why they're doing it, they're trying to say that this was somehow a removal proceeding. But it's not a removal.
Well, no, it wasn't. It wasn't. And that's at the heart of my issue with all of this, is that the only way the rules of civil procedure apply, and therefore 1.540, is if an adversary proceeding is commenced. I mean, that's under 5.025 of the probate rules. And so, which you're obviously familiar with because you were prepared for the question. But the issue, then comes back to is, why would we apply a general rule of civil procedure 1.540 over the more specific statute that particularly addresses how to remove a PR? And that was not done.
Two reasons, Judge Smith. One is this, and I'm going to repeat it again, was not a removal proceeding, despite what Mr. Cortinas said.
It
simply wasn't. If you start with a petition for administration, that's what happens in all estates.
Okay, well, would you at least agree? Would you at least agree with me, Mr. Goldman, that's what happened?
What happened? I'm sorry.
That the PR was removed?
Not at all.
No?
Not at all.
Okay. Well, if you vacate the order, Are they not in effect removed?
They are
Meaning-
no, that's not true. They are no longer personal representatives until they file, as they did, by the way, a new petition renewing their request. Then you have a hearing on that, and then you determine whether or not they are the personal representative.
Okay, so then address how do we apply 1540 in light of what you've agreed that you can only have an adversary proceeding for the rule of civil procedure to apply? What adversary proceeding was this 1.540 motion filed in?
So any proceeding can be declared adversary. 5.025A lists some that are deemed adversary, but otherwise everything else can be declared adversary. And in the record, and I don't have it in front of me, but all the proceedings that weren't deemed adversary, the proceedings themselves were declared adversary. And again,
And I'm still trying
nobody
to
has
find
disputed that. Nobody has disputed that until today. It's not even, it's nowhere else. Now, the other issue that Mr. Cortines brought up and indicated was another failure of 1.540 is a concern that the judge was applying 1.540 to a non-final order appointing a personal representative. And on pages 20 and 21 of my brief, I cover that very point, I hope thoroughly. And what the argument was that they made was that 9.170 doesn't list an order appointing a PR as a final order. But the Supreme Court was very careful. You make lists, you're always going to miss something. And so the way the rule begins is, here's this list coming up, but it includes but not limited to the following. And no one's ever taken away the requirement that it truly be a final order, which the Supreme Court, actually following this court's cases, has determined. And I give you on page 21 all of the cases, 21 and 22, that show that in fact an order appointing a personal representative is very much a final order. And the one case they say, Nafatel versus Pappas, proves their point. Actually, right within it says, in that case, the order appointing the personal representative was in fact a final order, and they were too late to appeal that. So let me talk.
Can you then provide me with your best case that where you undid the appointment of a PR, where they undid an appointment of a PR under 1.540 setting?
I can't, because I also, doubt that there's been an appeal of that. I can tell you that at one time, there was an issue of whether you could do a 1.540 motion under the probate rules. And of course, the answer to that question was you couldn't. You had to declare the proceeding adversary. But am I familiar with one? No, but nor do I believe there haven't been many 1.540 motions under various probate scenarios, because of course there are a lot of orders that come up in those cases. I don't have one specifically for or against, because it just hasn't been an issue in this case. So nothing we've had to research. But let me go back, if I may, to what the court did here, because I think it's important, because the implication is that the court has knocked out these PRs. They can't come back. It's required the conveyance, the trustees to convey back necessarily, and that's a final ruling. And that's exactly what the court did not do. What it said is, look, I'm looking at this petition and I'm looking at this consent, and it just reads misleading to me. So what I want to do is push the reset button, come back, notice these people, and let's hear what they have to say. And then I'll rule on it, whether your PRs or whether this transfer should be made. That's all the court did, and you can find. Sorry.
So let's go then. Okay, and so let's go back to the original inquiry, whether or not your clients were legally interested parties at the time that the other co-PRs were appointed.
Sure. So the case I want to talk about that is part of my answer to that question is Richardson v. Richardson. And in that case, not on all fours, but maybe on all threes with this one, you had a decedent and his widow was living. She was appointed personal representative of his estate, and the trust that he set up fully benefited her during her lifetime. She had all the power, including the power to appoint all of the assets to somebody else other than her children. Not only that, but she said in court, I am going to exercise my power of appointment against this one child who was objecting to her probate accounting that she had done. The court below dismissed the case, saying, well, that's at best a contingent beneficiary that doesn't have an interest, and the spouse says is never going to have an interest. And the fifth DCA reversed, saying, no, this is a contingent beneficiary, and under 731-201, at the time, point 21, I mean, paragraph 21, now paragraph 23, they're an interested person because they may reasonably expect to be hurt or at least affected by this personal representative. So Judge Silberman, I think you were asking about the conveyance issue, and in paragraph 5 of the motion for approval of conveyance, they talked all about the existence of Mrs. Bickett's trust and the fact that Mrs. Bickett really wasn't giving away these assets because it was going to an LLC that she controlled through the trust, not mentioning that it's a separate operating agreement. It's not run by the trustees, it's run by these same people who are the trustees individually. On the misleading part within the appointment of the personal representative, Judge Smith, what you have is the judge's concern about where this all went, and then he felt that they are, just as the Richardson court said, interested persons because what they do in the James Bickett estate affects their mother's estate that passes through this trust. So they quite reasonably may be affected by that. But let's go back. I'm exercising my discretion. Let's go back and look at this and push the reset button and start and see where we are. And so that's what he did. Whether you read the documents the same way he does, whether you might have done it differently, really isn't the question because it's abuse of discretion standard. One final area where, at least in their briefs, I didn't really hear it today. Oh, sorry.
Before you go on to that, I want to talk a little bit more about the interest of the 5 children that you represent. The actions that took place were in Mr. Bickett's estate. Set aside for the moment the question of the trust and the property. Were they interested parties in any way in the father's estate?
I believe they were interested only as a result of their interest in the mother's estate. And to answer your fact question before, he did not have alternate beneficiaries under his will.
And what Mrs. Bickett and the 4 children essentially did was seek a change in the devise that was provided for in the husband's will, correct?
Correct.
Now, had everything gone into the trust, she could have done exactly what she did, and the 5 children could not have interfered with that absent some claim of undue influence, fraud, some sort of misconduct. Is that right?
She couldn't. I think they would have had the power to be at that proceeding and object to it. And that's because they are contingent beneficiaries and have an interest in what happens there. But she could certainly, as the primary beneficiary of her trust, say, this is what I want to have happen.
Could they object to it absent some showing of lack of competence or, again, undue influence or fraud?
Yes, sir. That would be Richardson v. Richardson.
Right. I mean, they could try to object, but ultimately they'd have to establish that there was incompetence, one of those factors.
Well, not necessarily. What they might have to establish is this concept of transferring assets from the trust that they have a contingent interest in to an LLC is bad for the trust and all the trust beneficiaries.
So the point that I'm trying to get to is, it seems the 5 children did not have an interest in the father's estate, or I'll call standing to interfere in the father's estate, but for the effort by Mrs. Bickett to transfer property that would have gone into her trust from the estate, but was diverted or shifted out of the trust or away from getting into the trust into the LLC. And your bottom line position is that gave them the right to be heard under 1540.
Just heard, yep. Because they are under Richardson, even under those scenarios, even with the spouse, Margaret, the spouse in Richardson, having the power to appoint away from them, where they get nothing, promises she's going to do that. The court still said interested person.
Okay, and as far as their basis to intervene, did they at that time assert lack of competence?
I'm sorry, basis to intervene?
When they filed the 1540 motion, did they assert as part of that? I have a vague recollection that they asserted or raised a question as to Mrs. Bickett's competence.
I see what you're saying now. In terms of the motion, that was about notice. But what you may have read in our motion to dismiss, you may recall they had these renewed petitions, these renewed motions, and we responded to them. And in those responses, we did raise that, Judge.
Okay.
Yeah. Because we feel that the consent itself has got all kinds of problems with it, but that certainly wasn't for this day. It led to the ruling on the 1540 motion.
I guess there are a couple of things that happened. One, which is under Richardson, that seems to be the entree that you're riding on, the horse you're riding on to get involved in Dad's estate. Because
yeah, and it's essentially codified in a broader statute, which is 731-201-23. I mean, that's even broader than Richardson.
So that takes me, I guess, to what I think is my last question. In order for the trial court to determine the issues that it, in fact, determined, would the court have been obligated to make some determination as to her competence or undue influence to let the children, your clients, interfere under 1540?
Thank you for the question. And the answer to that is no. It absolutely would be an issue for the court to consider on a hearing on the renewed motions that were brought by the appellants. Absolutely, that's part of that. But in order for the judge to say, look, I'm exercising my discretion, I don't like the way these things read, the consent, not because it's necessarily she lacked capacity, but it's just wrong in my mind, misleading, and the petition itself was misleading. I want to bring in the other family members, the other heirs, and let everybody have a say in this. And then and only then am I going to rule on these issues in any kind of final way. But I'm sending you back on a reset to square one. That's all the court did.
That's I think, point, which is the effect of the trial court's order was in fact to remove the personal representatives. But the way the court seemed to have gotten there was with what you were suggesting, those orders were void from the beginning, and therefore the removal is a natural effect. it's not that you were necessarily seeking removal, you were seeking to declare the action in appointing them void.
Right. Well, it was a nullity, and whether they would then be able to come back and be the PRs, the court was very specific about it in the transcript and said, that's up to you guys. If you want to come back and do that, that's fine. But I should add, in case you're thinking this was sort of an end run of removal, we already had, and I put it in its page 1055 of the supplemental appendix, the order on injunction that appointed an ad litem to control both the estate and the trust. So that wasn't an issue, not at all.
Go ahead, you can proceed. You have a couple minutes left.
Thank you. The one last point I was going to make, Judge, involved an argument that was made that somehow, if we got back down to the renewed petition to appoint a PR, all this talk about taking evidence wouldn't apply because there's a specific statutory preference. This is what Margaret wanted, and the court has no power to consider those issues. And that's not the case. It is the case if the four had been appointed by the testator. Under that situation, your cases, Pintrello and versus Kepler and the state of Snyder, say under that scenario, it's automatic. You know, assuming they're qualified, assuming they're sui juris, that's the end of the discussion. But that's not true at all, even if you have some other preference under the preference statute. If the testator didn't appoint them, then the court has this power, and that's what those cases say. And Your Honors, I would emphasize, again, we all, you know, we're all human beings. We all have our own ways of doing things, but this judge did not act in an arbitrary way, did not act in a fanciful way, and should be affirmed. Thank you.
Thank you very much. Mr. Cortinas.
Yes, Judge. The first thing is I'll address Richardson v. Richardson and point out to the panel that that case is entirely inapplicable to the facts of this case. In that case, the fifth DCA considered the interests of children. The children had in trust established by their deceased father's will. The court determined that after their father's death, the children had a vested interest in the trust created by their father's will and were therefore, after the death of their father, interested persons under Florida statutes. Here, in contrast, the appellees are attempting to vacate orders based on entitlement to notice during Mrs. Bickett's lifetime. They were not entitled to notice under Mrs. Bickett's lifetime.
What I find interesting about that argument is Mr. Bickett could have changed his will at any time, which might have precluded things from going into the trust ever. I mean, to the extent she had joint ownership and she set that up, that'd be a different issue. And so it sounds like what you're saying is because he could have changed it, because she could have changed it, they really have no interest, except for the fact that he didn't change his will and your clients asked the court to effectively change the will. Is that?
No, Your Honor, and this is the problem. The transfers that were made, those orders transferring properties were made, one during Mrs. Bickett's lifetime.
Right.
I think the panel will agree that during Mrs. Bickett's lifetime, the appellees were not interested persons because Mrs. Bickett hadn't died. Until Mrs. Bickett dies, they are not interested people. And those transfers were made to a company controlled by Mrs. Bickett. So in effect, this is not the case. I mean, they continue to state things without proof. And this is not the case where the appellants are diverting any assets or items to themselves. Those transfers were made to a company that was owned by Mrs. Bickett. Your Honors, I will point out this to the court, and this is so the court is aware how the trial court was led into error. And this is on page 11 of the actual hearing on the Rule 1.540 motion. And this is appellee's counsel. He says, the second DCA said, he says, so what you have is a void order, no notice. I gave you the Purdue case in my memo of law. The second DCA said, and I never like to say this to a judge ever, but You have to do it. You have to set it aside. That's what the case says, Judge, not me. I'm just reporting the case. And one of the things you notice in this entire argument, in this entire briefing, Appellee's counsel nowhere relies on this Purdue case. In fact, the Purdue case actually helps our case. In that Purdue case, this court reversed the trial court order granting a Rule 1.540 motion based on lack of notice because the trial court failed to hold an evidentiary hearing. And I point that out to the court so that you see it's a moving target. They first say that they're interested persons and they try to weave into that argument, and they just can't weave into it because during Mrs. Bickett's lifetime, as a matter of clear Florida law, the appellees were not interested people. I will.
Let's go back to Richardson for a moment, because I just pulled it up to make sure what you said was a little different from my recollection. In Richardson, the husband died. He left the widow and 4 sons, and the will created the trust to the wife, and she had the absolute power of appointment over the remainder. I thought you had said that the children in Richardson were interested parties because the wife had died. And
No,
that's,
no.
okay, I thought that's what you had said.
No, I'm sorry. I apologize. Well, they were the children were because the father had died.
Right, which is similar to this case, right?
No, no, because the difference, Your Honor, is that here, when Mr. Bickett dies, they have no interest whatsoever. They only have an interest after Mrs. Bickett dies. Only after Mrs. Bickett dies.
It's different from what Richardson says. Herbert Richardson died, leaving a widow, 4 sons, and a will creating a marital trust and a family trust. Mrs. became the personal representative. She filed the final accounting petition for discharge, and one of the sons objected.
Because
the court said the appellant is a contingent beneficiary under the trusts, although his interest may never vest in possession or enjoyment, it is already vested in interest and in legal contemplation. So I'm not sure how you're drawing the distinction with that case.
I am, because it was not a revocable trust in that case. At that point, we don't know the facts of exactly what kind under that opinion.
The case does say that she had the power to do basically whatever she wanted to with the trust. So it may not have been revocable in the same way, and I haven't read it closely enough, but she clearly had the opportunity to do whatever she wanted to with the assets in the trust, which is comparable, at least, and by analogy, it's comparable to the circumstances here.
Well, Your Honor, to the best of my knowledge, again, there is no statute, no rule that makes them interested persons in Mr. Bickett's estate at the time of his death.
Okay. And why don't you take 15 seconds and wrap up?
And Your Honor, the last point, and that of course addresses only the interested person component of the argument. The other component is that, of course, no semblance of evidentiary hearing occurred with respect to the Rule 1.540 motion. So the order must be reversed for lack of an evidentiary hearing based on controlling cases from the second. We would respectfully request that the panel go ahead and vacate and deny the Rule 1.540 motion, or at minimum, remand for an evidentiary hearing. Thank you, Your Honor.
Mr. Cortinas and Mr. Goldman, it's good to see both of you. Thank you for appearing.